I'm Scott Shepard. I'm a shareholder here at Seltzer Kaplan McMahon Vitek. I'm in the litigation department. I've been practicing litigation for my entire career. There's a Ninth Circuit decision in a case that I've been handling for my client that really took on the interplay between the Federal Miller Act and state contractors licensing laws. This recent Ninth Circuit decision, Technica versus Candelaria and Carolina Casualty Insurance Company, the Ninth Circuit had to address whether or not the absence of a state contractor's license in California could be invoked to preclude the right to recover under the Miller Act for work on a federal construction project. And the Ninth Circuit followed some other circuits around the country in deciding that, in fact, yes, the Miller Act essentially trumps or takes precedence over the state contractor's licensing law. And so you can work on a federal project. You don't have to have a contractor's license in the state in which you're working in order to have the rights afforded to you under the Miller Act. The particular decision from the Ninth Circuit affects all federal projects within the Ninth Circuit. And so you have a number of different states out in the western part of the United States that are part of the Ninth Circuit Court of Appeals. This decision will be binding on all district courts in all those other states. It follows decisions by the 8th Circuit and the 10th Circuit, and we have 3 circuits pretty well aligned now. So it's a pretty fair bet that most other circuit courts of appeal that would consider this issue would rule the same way. This really has a really nice effect from a taxpayer point of view and from a federal contracting point of view. The idea is we want to get the most qualified bidders in a competition to see if we can't keep the price of construction going down. One of the theoretical benefits of this means that we should have, with more competition, an ability to keep the cost down and bring the quality up on federal construction projects.